Hello and welcome to Group Celeste. In this video, I will be briefly explaining on the topic of contract law. If you're not a lawyer, then have no worry because this video is intended for everyone regardless of whether or not you're practicing law. And so, by the end, hopefully you will be able to understand what the law of contract is all about. Keep in mind, however, that this video was made by university students and was not verified by any professional capacities. So we heavily encourage you to do your own research as well. So, what is contract law? Well, in Malaysia, contracts are governed in the Contract Act 1950, and it is the basic law that governs daily human activities in almost all aspects that can vary from simple contracts like buying groceries, all the way to more complicated issues such as providing consultancy services. Contract law intends to formalize an agreement between two or more parties in relation to a particular subject. This agreement then becomes legally binding between the parties and is enforceable by the law, meaning that if either party fails to uphold the agreement, it will result in certain consequences. However, in order for the agreements to be considered as contracts, they must fulfill essential elements which are as follows: offer and acceptance, consideration, certainty, legal capacity, free consent, and the intention to create legal relations. In law of contract, there are three different types of contracts that exist, namely the bilateral, unilateral, and collateral contracts. For the purposes of this video, we will be focusing on the unilateral contract. So, contracts. Every contract must at least involve two parties, that is, the person who proposes the contract, who is known as the offerer, and the parties to whom the proposal is made to, who is known as the offeree. Usually this is the case for bilateral contracts where each party takes on an obligation, usually in the form of promises. One party makes a promise to another party in return for their promise. It doesn't necessarily have to be one party, but rather multiple parties can also be involved. But as for the unilateral contract, this is where instead of multiple promises between multiple parties, only a single promise is involved. This is most commonly found in the form of contests and rewards. For example, Adam puts up a poster saying lost cat 500 ringgit reward, and Belle sees the sign. Now there's only one promise here. Adam has promised 500 ringgit to whoever can find his cat. So then let's say Belle performs and finds the cat. Now Adam has to keep his promise and pay the reward. So as you can see in our unilateral contract, we can see that the offerer is not looking for a promise, and performance is acceptance of the offer. So what I explained just now was a very simplified example of a hypothetical situation. So now let's take a look at a real case in Carlyle versus the Carbolic Smokeball Company of 1893. This is an important case because it emphasized the significance of offer and acceptance in contract law and distinguishes between offers and invitations to treat. So this case took place in 1892, and a medical firm, the Carbolic Smokeball Company, has advertised that its new wonder drug, a smoke ball, would cure people's flu, and if it did not, buyers would receive £100. The company even deposited £1,000 in the bank as a way to demonstrate their sincerity. During this time period, there was a flu pandemic going around that is estimated to have killed 1 million people. So this product called the smoke ball was created, and it claimed to be a cure to influenza and many other diseases. The smoke ball in question was a rubber ball with a tube fixed to its opening. The ball is filled with carbolic acid, phenol. The tube is supposed to be inserted in one of your nostrils, and the bottom part of the rubber ball is to be pressed. The gas enters your respiratory tract and flushes out all the viruses. So then comes along a Mrs. Louisa Carlyle, who would later on be the plaintiff, and believing in the accuracy of the statement made in the advertisement, bought one packet and used it accordingly as directed for about 2 months, until which she then had an attack of influenza. Afterwards, she and her husband wrote a letter to the company, who would be the defendants, stating what had happened and asking for the £100 as promised in the advertisement. The company refused, and this action was brought up to court. Arguments were heard on both sides, and in the end, the verdict was given in favor of Mrs. Carlyle, the plaintiff. The defendant's appeal was dismissed unanimously by all 3 judges, and Mrs. Carlyle finally received a compensation of £100. So, why was the defendant's appeal dismissed so easily? It was because the initial advertisement was in fact an offer, and it was a unilateral one made to the entire world. Mrs. Carlyle then used the smoke ball as instructed, and that counts as the acceptance of the offer. Finally, the companies claimed that £1,000 was deposited at the Alliance Bank, and this showed the serious intention to be legally bound. These are essential elements of contract, and this case forms the foundation for contract law. That is all from me. If you have any questions, please leave it down in the comment section below. Thank you for watching.